something unusual just happened inside the federal government, and hardly anyone is talking about it. Quietly, without flashy press conferences or wall-to-wall coverage on cable news, a brand new office began operating inside the Department of Justice. And this office isn't about restricting firearms, regulating ownership, or expanding enforcement. Its entire purpose is the opposite. For the first time ever, the DOJ has created a unit whose job is to actively defend the right to keep and bear arms, not as a side project, not as a symbolic gesture, as a formal civil rights mission. That single decision has set shockwaves through gun control organizations because it signals a fundamental shift in how the federal government is treating the Second Amendment. If you legally own a firearm, if you've ever applied for a carry permit, or if you've watched laws pile up year after year that seem designed to make exercising your rights as difficult as possible, what's unfolding right now matters to you in a very real way. The changes already underway aren't theoretical. They aren't campaign promises. They're happening through lawsuits, policy reversals, and structural changes inside federal agencies. And the truth is, most gun owners have no idea any of this is happening. That's what makes the next few months so important. When these actions start rippling outward into state courts and local governments, a lot of people are going to be caught completely off guard. Here's what triggered all of this. In early December of 2025, the Department of Justice formally launched what it calls the Second Amendment Rights Section. It sits inside the Civil Rights Division, the same branch of the DOJ that enforces voting protections, free speech rights, and protections against religious discrimination. That placement is not accidental. By putting gun rights in that division, the federal government is making a clear statement. The right to keep and bear arms is not a second-tier liberty. It's not a conditional privilege. It's being treated as a core civil right that deserves active enforcement when government entities violate it. This new section didn't spend months drafting mission statements or hiring consultants. It immediately went to work. Within weeks, it filed multiple lawsuits against jurisdictions that have spent years testing the limits of gun control through delay, obstruction, and creative legal workarounds. One of the first targets was a large West Coast county, known for its aggressive permitting restrictions. Applicants that were being forced to wait well over 2 years just to receive a decision on concealed carry permits. 2 years. That kind of delay isn't an administrative backlog. It's a functional denial. If a local government can stall indefinitely, it never has to say no outright. The DOJ's lawsuit argues exactly that, stating that extreme delays violate constitutional protections just as clearly as outright bans. Another lawsuit targeted a U.S. territory, where the permit process goes even further. There, officials require inspections of applicants' homes before approving carry permits, government agents entering private residences to evaluate conditions before allowing someone to exercise a constitutional right. That requirement alone raised alarms, and now it's being challenged directly by the federal government. The argument is straightforward. No other civil right requires citizens to submit to home inspections as a prerequisite. Then there's Hawaii. Lawmakers there passed a rule so restrictive that critics gave it a nickname that stuck. Under this law, even if someone manages to obtain a concealed carry permit, they are forbidden from carrying on any private property unless the owner has given explicit written permission in advance. No sign, no permission, no carrying. Combine that with an already massive list of public places where carry is banned, and the result is a right that exists almost entirely on paper. The DOJ didn't mince words. It called the law unconstitutional and filed suit, arguing that states cannot nullify a right by declaring nearly all locations off limits. Perhaps the most symbolic case of all involves the nation's capital. The DOJ has filed suit against Washington, D.C. over its prohibition on a commonly owned class of rifles. This marks the first time in U.S. history that the Department of Justice has affirmatively sued a jurisdiction to protect gun owners' rights under the Second Amendment. That alone signals how significant this shift is. The federal government is no longer standing on the sidelines or quietly supporting restrictive laws. It's stepping into court on behalf of citizens. All of this traces back to a directive issued earlier in 2025. A presidential order instructed the Attorney General to conduct a comprehensive review of every federal action taken over the previous 4 years that could be interpreted as infringing on firearm rights. That review included agency rules, enforcement practices, regulatory interpretations, and interagency initiatives. The order didn't ask for recommendations. It demanded rollbacks where violations were found. One of the first casualties of that review was a White House office created during the previous administration. That office had been framed as a violence prevention initiative, but in practice, it functioned as a coordination hub for gun control advocacy across federal agencies, staffed by individuals with deep ties to national gun control organizations. It pushed states toward adopting extreme risk orders, pressured agencies to reinterpret existing laws, to target private sellers, and even attempted to defund long-standing firearms education programs. Criminal misuse of weapons was rarely the focus. Law-abiding owners and the firearms industry were. Within days of the administration change, that office was dissolved, its programs were halted, its funding streams were cut. In its place came a fundamentally different approach. Instead of coordinating restrictions, the DOJ began coordinating enforcement of constitutional limits. The ripple effects didn't stop there. Inside the Bureau of Alcohol, Tobacco, Firearms and Explosives, long-standing enforcement practices were reversed. Under the previous framework, licensed dealers operated under what was known internally as a zero-tolerance policy. Minor clerical mistakes, the kind that happen in any paperwork-heavy business, were treated as grounds for license revocation. A missing initial, a transposed digit, errors with no connection to criminal activity or public safety. Dealers across the country were shut down over mistakes. That had nothing to do with guns ending up in the wrong hands. That policy has now been scrapped. In its place is a revised enforcement framework that distinguishes between willful misconduct and harmless error. Dealers who lost their licenses solely due to paperwork issues are being invited to reapply. Inspectors have been instructed to stop equating administrative mistakes with trafficking violations. This matters not just to gun stores, but to consumers. Fewer dealers means higher prices, longer travel distances, and reduced access. Restoring fairness at the enforcement level changes the entire market. And then there's the change that almost no one believed would happen. Beginning in early 2026, the long-standing federal tax on certain regulated firearms accessories drops to zero. For decades, acquiring items like suppressors or short-barreled firearms required paying a $200 tax and waiting months for approval. That tax was a relic of the 1930s, originally designed to discourage ownership by making the process expensive and slow. Through budget legislation passed in mid-2025, Congress eliminated that tax. The paperwork and background checks remain, but the financial barrier is gone. The regulatory agency responsible for processing these applications temporarily paused its electronic filing system. At the end of December to update procedures, officials expect a surge in applications once the new rules take effect. For many owners who were previously hesitant, the elimination of the tax changes the calculation entirely. Not everything happening right now is straightforward. One of the most controversial topics in the firearms debate remains so-called red flag laws. These statutes allow courts to temporarily remove firearms from individuals deemed a risk to themselves or others, often based on petitions filed by family members or law enforcement. As of now, more than 20 states and the District of Columbia have such laws on the books. The federal government has not yet filed lawsuits directly challenging these statutes. However, its position has become increasingly clear. Senior officials have publicly criticized the lack of due process in many of these systems, pointing out that initial orders are often issued without the affected person present or represented. Federal funding that previously encouraged states to adopt or expand these laws has been redirected. The message is subtle but unmistakable. While the DOJ isn't overturning these laws directly, it is no longer promoting them, defending them, or financially supporting their expansion. At the same time, momentum at the state level is shifting. Several states have passed laws explicitly prohibiting courts from issuing firearm removal orders based solely on predictive risk assessments. These bans were enacted through state legislatures, reflecting local political shifts. Meanwhile, other states continue moving in the opposite direction. In one northeastern state, voters approved a red flag statute through a ballot initiative with a sizable majority. The country remains divided, but the battleground has clearly moved away from Washington and into state capitals. Above all of this looms the Supreme Court. Several major Second Amendment cases are waiting in the wings, and the court has signaled growing impatience with lower courts that continue to uphold restrictive laws. Despite recent precedent, A long-running challenge to magazine capacity limits in a western state has repeatedly been sent back for reconsideration, only to be upheld again. Many observers believe the justices are preparing to step in and resolve the issue directly. Another case challenges a sweeping prohibition on a broad category of firearms in the Midwest. During prior opinions, at least one justice openly suggested that the court could not avoid addressing such bans forever, a ruling that would have national implications, affecting laws in multiple states simultaneously. Perhaps most quietly significant are dozens of cases challenging lifetime firearm prohibitions for individuals convicted of nonviolent offenses. These cases argue that permanent bans, imposed without individualized assessments, violate constitutional principles. The number of challenges has grown so large that consolidation is likely. Meanwhile, federal regulators have proposed a rule that would create a formal process for restoring rights in certain circumstances, marking a dramatic shift from previous policy. Still, the picture isn't uniformly positive. Even as the DOJ advances these protective actions, it continues to defend the broader regulatory framework governing certain firearms. In court, government attorneys are arguing to preserve long-standing statutes despite recent changes that undermine their original justification. Advocacy groups opposed to gun ownership have been allowed to submit arguments in support of these restrictions, some of which rely on disputed claims. The result is a complex legal landscape where progress and contradiction coexist. At the state level, developments vary widely. In some regions, courts have blocked expansive lists of so-called sensitive places where carry is banned, citing constitutional concerns. In others, appellate panels have reinstated those laws, setting the stage for further review. In one southwestern state, a waiting period for firearm purchases was struck down, and higher courts declined to revive it, creating a precedent that could influence challenges elsewhere. Political turnover has produced renewed pushes for restrictive legislation. In a mid-Atlantic state, newly elected leadership has signaled support for permit-to-purchase requirements, expanded firearm bans, and broader use of removal orders. Those measures are likely to pass, shifting the focus back to federal courts for relief. All of this adds up to a moment unlike any other in modern American history. For the first time, the federal government has established an institutional mechanism dedicated to enforcing the Second Amendment as a civil right. It has backed that commitment with lawsuits, policy reversals, and structural reforms. At the same time, opposition remains strong, and future administrations could attempt to reverse course. What happens next will depend on courts, elections, and how closely citizens pay attention. Laws are changing, cases are moving, precedents are being set right now, not years from now. Staying informed isn't optional anymore. It's the difference between reacting after the fact and understanding what's coming before it. Rise.